Motion relating to the business or the sitting of the Senate.
I recognize the leader of government business.
Madam President, I move that at its rising today, the Senate adjourn to a date to be fixed by the President.
All those in favor? Honorable members, the question is that at its rising today, the Senate adjourn to a date to be fixed by the President. All those in favor, kindly say aye. Those against, kindly say no. I think the ayes have it.
Public business, government business, motion.
I recognize the leader of government business.
Madam President, I move that whereas the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards was adopted by United Nations Diplomatic Conference on the 10th June 1958 and entered into force on the 7th June 1959. And whereas the objective of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards is to require courts of contracting states to give effect to private agreements to arbitrate and to recognize and enforce arbitration awards made in other contracting states. And whereas in 1980, prior to independence, the then legislature amended the Arbitration Act to add Part 3 and the 4th Schedule, which set out the convention in total, with the express intention to give effect to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And whereas the New York Convention has been ratified by the United Kingdom on the 24th September 1975 and made applicable to Belize by notice of territorial application in the form of a declaration by the United Kingdom, which was received by the Secretary General of the United Nations on 26 November 1980, some 6 weeks after the enactment of the 1980 ordinance. And whereas since 1980 the convention has been a part of the laws of Belize, but it has never been ratified by Belize, and whereas the government is desirous of completing the formalities by ratifying the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards pursuant to Article 8 of the Convention, and whereas Section 61A(2)(a) of the Belize government, as amended by the Belize Constitution, 6th Amendment Act No. 13 of 2008, provides that the Senate shall authorize the ratification of any treaty by the government of Belize. Now therefore be it resolved that the Senate authorizes the government of Belize to ratify the United Nations Convention on the Recognition, Enforcement, and Enforcement of Foreign Arbitral Awards, a full text of which is hereto annexed. Madam President, on opening the debate on this issue, there are a few important points that I would like to highlight and to address some of the issues which I understand has been in the public domain. The first point, Madam President, to make clear to this Honorable Senate is that the New York Convention, which we seek permission of the Senate to ratify, is and has been the law of Belize since 1980. More than 40 years ago. It has been the law of this country. In fact, it was the law of this country prior to independence. Madam President, it is therefore important for us to appreciate that all that is left now is the formal act of ratification. This is not something new. It is completing the legal and formal requirements for Belize to become an actual party to the convention. The second point I'd like to address, Madam President, is the question of why and why now. I make clear, I state as a fact, without the possibility of contradiction, that the matter is brought before the Senate today because the government of Belize is in the process of negotiating a debt instrument with counterparties, one condition of which is the ratification.
Keep the talking down. Please proceed.
The ratification of the New York Convention. Madam President, members of the Senate, that negotiation is something that began with the United Democratic Party administration, inherited by the current administration, which we perceive that if it is concluded, is in the public interest. This is not something that started with the current administration. It is something that predated our coming to office. Madam President and members of the Senate, I would prefer not to go into the details of what is being negotiated. I would prefer not to name the parties involved because the negotiations are at a stage where they have not been concluded, and I am hoping that in the interests of Belize, politics does not interfere with the concluding of something that began with the previous government that we are seeking to conclude now. The fact of the matter is, Madam President, the current administration inherited a debt crisis. And it is important to put in context where we are. The fact of the matter is, Madam President, and if you go back to 1998 when the People's United Party was then brought into government, the public debt stood at $560 million. When the United Democratic Party came to power in 2008, 10 years later, it stood at $2 billion. An approximate addition of $1.5 billion. The debt stock today is more than $4.2 billion. More than $4.2 billion. The debt to GDP ratio is approximately 135%. Best practice, 60 to 65%. We are double that, more than double that. The domestic debt owed by the government of Belize to banks in Belize and to the central bank, Madam President, moved from $300 million in 2008 to $1.3 billion today. The simple point I seek to make is that regardless of whether you say the PUP or the UDP, these facts are the objective facts that we as a nation are confronted with. The negotiations that we are involved in, which were begun, I repeat, which were begun under the previous administration, is designed to address the urgent crisis that this government faces, that this country faces in meeting its debt obligation. I repeat, we are here now because the negotiations are at the point where the counterparties are saying there was an obligation to ratify. We need it for this transaction to move forward. I think it is important for me, Madam President, to underscore for those who are listening that we are facing a fiscal deficit of such an amount that we are unable on the current path to pay our obligations as they come due. It requires debt relief. That is what we're engaged in. I want to emphasize that the New York Convention is a part of the law of Belize and has been a part of the law, as I said, since 1980. What is important, Madam President, in my respectful view, is to see what it is that the Caribbean Court of Justice has had to say on this matter. In 2013, Madam President, the question arose whether or not, since Belize had not ratified the convention, it was applicable. The case went all the way to the Caribbean Court of Justice. I read from a judgment of the Caribbean Court of Justice dated the 26th July 2013, paragraph 65. The court said, with your permission, Madam President, on the 10th October 1980, during the era of self-government, but before attaining independence, the Belize legislature enacted the Arbitration Amendment Ordinance, which came into effect on the same day, 10th October 1980. By the 1980 ordinance, the legislature added Part 3, Sections 25 to 30, and the fourth schedule titled the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards to the Arbitration Ordinance of 1932. The actual Arbitration Act of Belize came into force in 1932. We have a history of arbitration law in this country. The CCJ continues. The 1980 ordinance was expressed to be, quote, an ordinance to amend the Arbitration Ordinance, Chapter 13 of the laws to give effect to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. The New York Convention had been ratified by the United Kingdom on the 24th of September 1975. We're still a colony, and made applicable to Belize by notice of territorial application in the form of a declaration by the United Kingdom, which was received by the Secretary General of the United Nations on the 26th November 1980, some 6 weeks after enactment of the ordinance. The CCJ, the highest court of Belize in 2013, settled as a matter of law that the Arbitration Act was amended in 1980 to give effect to the New York Convention and to make it a part of the law of Belize, notwithstanding the fact that the formality of ratification had not been completed. So the question, Madam President, of whether the New York Convention is a part of the law of Belize is no longer open to discussion or debate by anyone. It has been settled by the highest court of this country. Madam President, I wish now to turn to another issue that appears to be of concern. And this is the question of arbitral awards already issued against the government of Belize and whether or not they will be covered or there is some benefit to be gained by the ratification of the New York Convention. I checked with the Financial Secretary yesterday. Financial Secretary confirmed to me that there are 3 awards. 3 out there. The first award was the subject of a CCJ case. The Caribbean Court of Justice held that it would be contrary to public policy for that award to be enforced in Belize. It means that it cannot be enforced in Belize. That award was taken to the United States of America, where the United States courts recognized the award and said it could be enforced. However, up to today, there has been no enforcement of the award for the simple reason that there are no assets of Belize that can be attached. The second award that the Financial Secretary spoke to was the award that is known as the UHS case. That matter was litigated, Madam President and members of the Senate, and the Caribbean Court of Justice in 2017, 22nd of November 2017, made an order and said that that award can be enforced in Belize. So the case in relation to that is finished. It's just a matter of when and if there will be collection on that award. The third award is one in favor of a company called Belize Social Development Limited, which the Financial Secretary told me, I believe that it is more than an award of approximately 8 to 10 years old. I'm not sure of the date. But the point he made to me is there has never been any attempt to enforce that award. As I understand it from the Financial Secretary, those are the 3 awards, and that is the status. One cannot be enforced in Belize by order of the CCJ. The second, by order of the CCJ, can be enforced in Belize. And the third, there has been no attempt to enforce that award. Madam President, against that background, against the status of the convention as held by the CCJ to be the law of Belize, I say to this Honorable Senate that the formality of ratification provides no legal benefit because it's already a part of the law of Belize. Nevertheless, the government has sought legal advice, and we have been advised that one step that can be taken, which will give an assurance, is when Belize ratifies, it enters a reservation. What does that mean? That Belize will say, we ratify this convention, but we reserve the position that it will have no retroactive effect. It will not apply, as far as Belize is concerned, to awards made prior to Belize's formal ratification. It is the intention of the government, Madam President, that if this Senate authorizes ratification, to enter a reservation as advised by international arbitration experts to the effect that Belize's ratification is on the basis that it will not have retroactive effect. I therefore emphasize, Madam President, that we are here today in order to take a step to address a national debt crisis. I emphasize, Madam President, that the New York Convention is already and has been a part of the law of this country for over 40 years. I emphasize, Madam President, that we are involved in delicate negotiations at this stage, which have not been concluded. One of the conditions for conclusion was the ratification of this convention. The United Democratic Party administration agreed to it. It did not do it. We are continuing those negotiations, and we are now doing that which they said they would do. Finally, I emphasize that on ratification, if authorized by this Honorable Senate, we will enter a reservation, that we do so on the basis that it should not apply to awards already made. I conclude on this point, Madam President. I have had consultations with members of the Senate prior to today, seeking to address their concerns. I am aware that high-ranking government officials have also had consultations with members of the Senate, seeking to address their concerns. Madam President, I say with emphasis, senators have been assured that this ratification has absolutely nothing to do with Michael Ashcroft and his companies. This, Madam President and members, is a resolution about debt management. It is about investment confidence. It is about the rule of law, and it is about sound diplomacy. And I hope, Madam President, that after debate, it will enjoy the support of the Senate. Thank you, Madam President.